Okay, good afternoon, everyone. We are here for oral arguments in the matter of Algonquin Gas Transmission LLC, consolidated docket numbers 2017-011 and 2017-012, concerns a Chapter 91 waterways permit. We're here because the Superior Court remanded the matter back to the department based on what the court determined was an error of law with regard to the interpretation of 310 CMR 9.02 and the definition of an ancillary facility to an infrastructure crossing facility. The parties have briefed the issue. The tenant residents group requested oral argument, which I allowed, and that's what we're doing today. I've asked the applicant to proceed first, and as I notified the parties last week, each party will have 15 minutes for their initial presentation, followed by 5 minutes of rebuttal time. Any questions before we go forward? Okay, and I'll remind everyone that this is being recorded on Zoom and live streamed on MassDEP's YouTube channel. Okay, Mr. Cramb.
Good afternoon, Ms. Presiding Officer. I am Nick Cramb, and I'm counsel for Algonquin Gas Transmission. So I'll begin at what I think really is the central question, or the central point, and that is that the record overwhelmingly demonstrates that the compressor station requires a location adjacent to the hub line or the I-10 because it is necessary and because it is demanded because it is suitable and appropriate. How do we know that? There is no real dispute that in order to meet the purpose of the Atlantic Bridge project and to allow for gas to flow from the south to the north in the hub line and meet Algonquin's customers' needs, compression is needed at the southern end of the hub line. That is where the pressure differential or the bottleneck exists, precisely where the compressor station has been cited. You can't simply put the compressor station elsewhere and provide the necessary compression at the south end of the I-10. Why? Because every single alternative that Algonquin considered and studied involved constructing miles and as much as 30 miles of additional suction and discharge pipeline to take gas from the system at the lower pressure and deliver compressed gas back to the hub line where compression is needed. You cannot just pick up the compressor station facility and put it somewhere else without the development, permitting, and construction of miles of additional pipeline. And that alone demonstrates that the compressor station requires a location adjacent to the hub line. The compressor station needs an adjacent location because that is exactly where the pressure differential exists and where compression is necessary. Now, beyond that, the record further shows that while the compressor station is presently located entirely on filled tidelands with short suction and discharge pipes that are contained on site on filled tidelands, all of the alternatives that were studied would require significant additional infrastructure, increasing the environmental impacts of the project, and all would involve impacts to areas subject to jurisdiction under Chapter 91, and unlike the present location, in each case, impacts to flowed tidelands. These additional impacts and the impracticality of siting the compressor station further establish that a location adjacent to the hub line is necessary and required because it is suitable and appropriate. And just to highlight some of the examples, Algonquin explored 3 alternative sites in Weymouth. Each of them involved approximately 5 miles of additional pipeline because in each case, you would have to connect the compression back to the beginning, the interconnection between the I-9 and the hub line where the pressure differential exists. The first Weymouth site involved 7 road crossings, a railroad crossing, and 5 water body crossings, 20 acres of forested lands, and other impacts. The other two Weymouth sites are similar. Algonquin also explored alternatives that were further out in Franklin and in Holbrook. These involved as many as 30 miles of additional pipelines. Holbrook was about 7 miles of suction pipelines, 9.5 miles of discharge pipelines. It would have involved 8 water body crossings, 21 road crossings, 3 railroad crossings, etc. They also studied potential locations to the north on the maritime system, both on Children's Island and on Long Island. These also involved the construction of miles of additional pipeline. They had even more extreme environmental impacts because of the nature of the islands and the benthic zone disturbances, the ocean floor disturbances that would be required, and horizontal directional drilling. And the record establishes that they wouldn't actually solve the pressure differential and likely couldn't even be permitted. So I guess in addition, we heard from the town's witness, Mr. Powers, 3 potential suggestions. He said, first, well, you could just build an I-10 extension that would involve 20 miles of a larger diameter pipeline, and somehow that would solve the problem. But the evidence showed, and Mr. Bocock testified, that that wouldn't work due to the pressure limits on the I-10 system. And Mr. Powers actually conceded on cross-examination that in addition to this extension, additional compression would be necessary. He suggested adding compression in Burrville, Rhode Island, which is the site of one of Algonquin's compressor stations. But Mr. Bocock testified that this would involve 50 miles of pipeline in this instance, with all of the associated impacts. And in fact, testified that Burrville is too far away because of the distance between that site and where the compression is needed, and that you would lose pressure along the way. Mr. Powers also suggested lowering pressure on the hub line system itself to encourage gas to flow from the south to the north. But the record demonstrated, and Mr. Bocock testified, and as you have found, that would cause unacceptable delivery problems on the maritime system and would not satisfy the needs of the purpose of the Atlantic Bridge project or the needs of Algonquin's customers. As you found in the first instance, and as you should find here again, all of Mr. Powers' suggestions were not reasonable, were not workable from a practical perspective, or would result in not being able to deliver gas as necessary to Algonquin's customers. So all of this leads to the question of what exactly you should be considering when you determine whether or not something is, whether an adjacent location next to the hub line is required. And what the court has instructed is that instead of simply meaning suitable and appropriate, required means that the location is required, demanded, or made necessary because it is suitable or appropriate. And while the court has said that it wouldn't be unreasonable to find that requires means necessary, it has not instructed the DEP to apply that definition. And instead, what it has instructed the DEP to do is use this longer form definition that I just articulated, which includes various concepts that evidence a less restrictive meaning. They incorporate the concepts of demand, of suitable, of appropriate, and of compatible. And each of these is less restrict than absolutely necessary. Demand is defined to include what is called for as useful or necessary. Suitable means adapted to a use or purpose. Appropriate means especially suitable or compatible. And compatible is defined, as might be very appropriate here, to include designed to work on another device or system without modification. And of course, the compressor station could not supply the necessary compression here in any other location without substantial modification in the form of additional infrastructure. You had also expressed an interest in the non-exclusive list of examples that were provided by the regulations. And they further help understand exactly what required means, in that they include facilities that would be technically possible, but impractical to locate away from the facilities to which they are operationally related. We focus on the toll booth, on power transmission substations, and on gas meter stations in our brief. We think that toll booths provide the most practical example that anyone can understand. It makes sense if you're charging a toll for a bridge to locate the toll adjacent to the bridge, but that's not absolutely necessary. You can imagine a circumstance whereby lanes or some other means you can move a toll booth back from a bridge and outside of Chapter 91 jurisdiction and still charge a toll for the bridge. Or much like the residents have suggested here, you could do something much more complicated. And like constructing miles of pipelines to try to move the compressor station away from where the compression is needed, you could construct lanes and roadways and some other systems to move a toll booth away from the bridge that it serves. The same is true with a power transmission substation, and we've supplied some authority from Ohio that is not directly on point, but it demonstrates that transmission substations can be located in various places, and wherever they are located depends on the length of the interconnection between cables back to the site where a power conversion was necessary. And we think just like the toll booth and just like power transmission substations, gas meter stations too, practically are often and reasonably located next to the pipeline crossings that they serve. But just like in this case, where the residents have suggested installing all this additional pipeline to put compression elsewhere, in the same way, one can envision installing additional pipeline to move a meter station away from a crossing. And what all of this suggests is that requires an adjacent location cannot mean that the facility cannot technically be located somewhere else without some other consideration of the practicality and the reasonableness and the impacts that are associated with technically feasible alternatives. And we think it would be inconsistent with DEP's broad statutory mandate and regulatory duties, including the promotion of the best usage of land and water, and taking account for the overall public trust in waterways to interpret requires in any other way. I think that I'm running short on time, but I did very briefly want to address the scope of the remand and what the court and the commissioner has asked you to do as presiding officer is to apply the court's definition of requires an adjacent location to the compressor station and the hub line to determine whether it constitutes an ancillary facility. All other issues fall outside of the scope of the remand. One of the issues that the residents focus on in their brief is environmental justice. That first is plainly outside of the scope of remand. And second, as you will likely recall, the First Circuit addressed environmental justice claims in the air appeal. And there it found that the compressor station did not trigger MEPA environmental impact report thresholds. And in any case, Algonquin and the department had provided for enhanced public participation procedures consistent with the EJ policy that enforced. The residents here cite the since enacted roadmap for Climate Policy Act, suggesting that it somehow applies retroactively. And in fact, it says the opposite. If you look to section 102B of that act, it says that provisions regarding environmental justice triggers for environmental impacts reports apply to new projects filed after the regulations are implemented. That happened in December of 2020, as I understand. And here, this project was filed in December of 2015, which is when the Chapter 91 application was initially filed. And you don't just have to take it from me, because that's exactly how the department itself explained application of that statute in its brief filed with the First Circuit in the air appeal. And I will rest there.
Okay, thank you, Mr. Cramb. Mr. Fallon.
Hello, excuse me. Thank you, Madam Hearing Officer, for giving us an opportunity to address you with the oral argument on this. So the issue that's presented here on the remand is from the department's view, it's really quite simple. It's a pure question of law relating to the meaning of a term in the department's Chapter 91 regulations. The term is requires. And the question we're looking at is, may a compressor station be licensed under Chapter 91 as an ancillary facility to an infrastructure crossing facility because it requires an adjacent location to the infrastructure crossing facility, that here being the hub line. So the court on remand directed us to reassess our licensing of the compressor station as a structure that requires an adjacent location. And the court defined the term for us to follow requires, meaning to call for as suitable or appropriate, meaning that something is required, demanded, or made necessary because it is suitable or appropriate. So going back through the administrative record, the department finds that there is substantial evidence in the record to support the conclusion that the compressor station is the type of structure the regulation would allow to be constructed in Chapter 91 jurisdiction under the court's definition of required because of its purpose and function, requires it to be adjacent to the hub line. And what I would like to focus on first is the fact that the purpose of this regulation is to allow for the—
Okay, I need to be co-host.
I'm sorry?
Oh, that was Mr. Ferguson. Can you please make Mr. Locke co-host? Apologies. Please proceed, Mr. Fallon.
Thank you, thank you. Just going back, I would like for all of us to focus on the purpose of the regulation. The purpose of this regulation is to allow for the licensing of something that may not typically be properly licensed in the Chapter 91 jurisdiction, particularly because you don't always know what new facility or structure may be necessary to construct it in the future. This regulation does not allow for any type of structure an applicant wants to be constructed on a site for convenience sake. For example, an employee recreation facility would not be required to be adjacent to the hub line, or a company vehicle repair shop would not be required to be adjacent to the hub line. You need to show something that shows a reason why it's required to be adjacent to the hub line. And here the applicant has presented substantial testimony to support that conclusion that the compressor station is required to be adjacent to the hub line under the regulation to minimize additional infrastructure construction, to minimize additional environmental impacts, and the fact that it will operate within a pre-existing utility corridor makes it an appropriate placement for the compressor station adjacent to the hub line. And we also want to emphasize the meaning of the word requires here is not a question of feasibility. Is it feasible to construct the compressor station half a mile away from the hub line? It may well be feasible to do that. But the real question that we are looking at here is one of regulatory interpretation and applying the regulation in a rational manner, remembering that this regulation specifically allows for the construction of structures that may not ordinarily be allowed in Chapter 91 jurisdiction. There are requirements that must be met before a structure can be licensed as an ancillary facility. The regulation gives us guidance on how to look at this required to be adjacent to factor and determine the appropriateness of issuing a Chapter 91 license to a structure that is operationally related to the infrastructure crossing facility. And much like the applicant, the department did focus on the toll booth example in the regulations because that is an example of something that is allowed for under the regulations as being required to be adjacent to. So is a toll booth for a bridge or a road required to be adjacent to the bridge or the road in order to function? Is it feasible to construct a toll booth not on the actual bridge or on the actual road, but somewhere else? Well, the answer is yes. You can construct an off-ramp, you could build a toll booth a half a mile away, construct an on-ramp, then redirect the traffic back onto the bridge or onto the road. That is possible. But that makes no practical sense, and it's not a rational approach to how the regulation should be applied. The toll booth is required to be adjacent to the road or the bridge because being adjacent to is called for as necessary for its proper functioning. It's required to be adjacent to the road because it's suitable to the purpose of the road, allowing traffic to move over the infrastructure crossing facility, which would be the road. It's appropriate to be adjacent for the proper flow of traffic. This is an example of something that could be built somewhere else, not adjacent to the infrastructure crossing facility, but is specifically allowed by the regulation as an example of something that requires an adjacent location. And another example, the same would apply to tunnel ventilation buildings. You could construct them half a mile away from the tunnel, but it is necessary and suitable and appropriate to place the ventilation system adjacent to the tunnel because it reduces impact to the environment, it reduces additional infrastructure construction, and is more efficient in terms of less sections of ventilation to install. All of the examples in the regulation are examples of structures you could place away from the infrastructure crossing facility. However, the regulation specifically allows these types of structures to be built adjacent to the facility under the rubric that it's required to be adjacent to. These are practical examples of what's allowed to be constructed under the regulation. It is not absolutely mandatory that these structures be built adjacent to the infrastructure crossing facility they support, but as a practical matter, the regulation allows them because they're required to be adjacent to the facility because it makes sense, because it is suitable, because it is appropriate. This is a rational application of a regulation that allows for an exception to what may typically be constructed in Chapter 91 jurisdiction. The regulation applies a rational and a practical approach through the examples to the question of what types of structures require an adjacent location. Using the examples in the regulations of what is allowed and applying the court's definition of required that the court instructed us to follow, you really can only reach the conclusion that a structure like a compressor station requires an adjacent location, and it is appropriate because, like all the other examples in the regulation, its function requires at some point that it be connected to or contact the infrastructure crossing facility. The toll booth is an allowable structure to be constructed adjacent to the infrastructure crossing facility because that placement is demanded or made necessary because it is suitable or appropriate for a toll booth beyond the road it collects tolls for. It is not mandatory that it be placed there, but is made necessary because it is suitable and appropriate to its function. The same applies to the compressor station. It is suitable and appropriate to place it adjacent to the hub line. The commonality of all the examples cited in the regulation that will allow for these types of structures to be built adjacent to an infrastructure crossing facility is that all of them require some type of direct contact with the infrastructure crossing facility to function. The gas metering station has to connect somewhere to the gas pipeline. And you really want the sewage headworks and pumping facilities to be firmly connected to the sewage line. The compressor station is no different. It's required to be adjacent to the infrastructure crossing facility in the same manner as the examples cited in the regulation. It has the same nexus. It is appropriate and allowable under that regulatory requirement. And thank you.
Thank you, Mr. Fallon. And I understand there was a delay in the live stream on the YouTube. Is that correct, Mr. Ferson?
Yes, that's correct.
Okay, we are now streaming live, and for anyone watching live on YouTube, apologies for the delay. This is also being recorded on Zoom, and we will be able to make the Zoom recording available to anyone who is interested. Contact the Office of Appeals and Dispute Resolution, and we will make that available. So thank you, Mr. Ferson. Okay, Mr. Hayden.
Thank you, Madam Presiding Officer. Michael Hayden on behalf of the 10 Residents Group. I will use the time that I have both to respond to some of the arguments presented today by the applicant and the department, but also to reply to the briefs that the applicant and department filed in connection with this remand proceeding. At page 5 of the applicant's brief, there's a statement, construction is now complete and FERC authorized the compressor station to go into service on September 24, 2020. That fact would have postdated all of the underlying testimony received in this matter. And so I did want to add some additional context to that statement having been made. And that is on January 20th of 2022, FERC issued an order on briefing and addressing arguments raised on rehearing. FERC docket number CP 16-9-11 and 12 and 178 FERC paragraph 61,029. The chairman of the FERC Board of Commissioners, Mr. Glick, made this statement in that order on briefing and addressing arguments raised on rehearing. In my opinion, the commission likely erred in citing the Weymouth compressor station where it did. This facility is located in a heavily populated area that is home to 2 environmental justice communities. Those communities have borne a disproportionate burden from a legacy of industrial activity, including elevated rates of asthma, certain cancers, and other serious illnesses, particularly in light of that history. Petitioners' concern about the impacts of the Weymouth compressor station and the blowdowns it has experienced is legitimate, understandable, and frankly, inadequately addressed in the underlying certificate orders. What's fascinating about where we are now 6.5 years after the applicant's Chapter 91 Waterways license application was filed is that the focus of the last 6.5 years has been rightly upon the compressor station itself. But on the remand proceeding, as made clear by the Norfolk Superior Court's order, the focus today belongs on the hub line, because it is the hub line that is the licensed infrastructure crossing facility to which the applicant seeks to attach an ancillary facility. The focus is not the entire Atlantic Bridge project, and the focus is not the convenience or inconvenience of placing the compressor station in a particular location. The focus needs to be on the hub line itself. And as the testimony established in an abundantly clear fashion, the hub line has been operating and functioning perfectly fine since it was licensed almost 20 years ago in 2003. In the applicant's application that was filed back 6.5 years ago, as noted in the 10 residents group's brief, there's only one reference to the term ancillary in connection with the compressor station in that entire application. That's noted in the 10 residents group brief, paragraph 10. It's repeated twice, but it's the same language that's used in that application. And the applicant's witness, Mr. Tyrell, agreed that that was a conclusory statement, and that's cited in the 10 residents group brief at paragraph 11. In the applicant's brief on this remand at page 4, page 14, page 15, and page 16, reference is made to the compressor station being necessary to achieve the Atlantic Bridge project purpose. That is the phrase, the Atlantic Bridge project purpose that is utilized, not to facilitate the hub line, not to allow the hub line to work in any better or different fashion. In fact, there's been no evidence submitted in this proceeding that the hub line is broken, deteriorated, expired, or in need of repair. The hub line has been working fine and for the purpose that it was licensed for since 2003. The department's brief at page 8 stated the placement of the compressor station at the site is the best location to achieve the project goal, and cited testimony from Mr. Bocock, who stated adding compression somewhere is required to meet the AB project purpose, AB standing for Atlantic Bridge. Again, nothing has been offered by the applicant or the department that suggests that the hub line in and of itself, as the infrastructure crossing facility that was licensed in 2003, requires any ancillary facility, whether it's a compressor station or any of the other examples that are listed in the CMR, to function, because it's been functioning perfectly fine on its own since 2003. The Norfolk Superior Court's decision resulting in this remand stated at page 7, there is nothing unreasonable about limiting ancillary facilities to those for which a location adjacent to an infrastructure crossing facility is necessary. What this means is that the hub line itself must require, demand, or make a compressor station necessary. It's not a question of whether the Atlantic Bridge project can succeed or fail, depending upon whether this compressor station is placed on the north parcel in Weymouth. It's a question of whether the hub line can succeed or fail. And the answer is unequivocally that the hub line has been functioning without any problems for nearly 20 years. Moreover, because it's the hub line that is the licensed infrastructure crossing facility, the DEP's entire review of the hub line application would have been markedly different if it included a compressor station within that proposal. It is undisputed that there was no mention of even the potential for a compressor station to be sited on the north parcel back in 2002, when the hub line was under review, in 2003, when the hub line was licensed. Attached as Exhibit 1 to the 10 residence group brief is the mitigation project that was entered into between a number of departments, including the Executive Office of Environmental and Energy and Environmental Affairs, as well as the Department of Fisheries and Marine Fishery. Whether a compressor station would have been considered by the applicant was extremely relevant to the mitigation project that was determined back in 2003. And it is a reason for the compressor station not to be approved as an ancillary facility now 20 years later. The examples that are stated in 310 CMR 9.02 of ancillary facilities, and in the 10 residence group brief, we went through each and every one of them. Power transmission substations, gas meter stations, sewage headworks and pumping facilities, toll booths, tunnel ventilation buildings, drainage structures, approaches, ramps which connect bridges or tunnels to adjacent roads. They can't be placed anywhere else because the infrastructure crossing facility to which they relate needs them to function. A tunnel needs ventilation or the tunnel can't function. Sewage headworks and pumping facilities are required for pipelines. Otherwise, the pipeline or bridge or tunnel can't function. Here, we've got 20 years of evidence that the hub line has functioned perfectly fine for nearly 20 years without a compressor station. There's no dispute that the hub line can function for the purpose for which it was licensed. What the applicant is asking the department to do is consider an alternate use. The applicant has a business prospect tied to the Atlantic Bridge proposal, which allows them to reverse the flow of natural gas from a north to south direction to now a south to north direction if a compressor station is added. But the evidence is clear that compressor station can be placed in a number of different locations, or not at all. We can add compression in Burrillville, Rhode Island by adding pipeline without a compressor station and accomplish the Atlantic Bridge purpose. But again, whether or not the Atlantic Bridge purpose can be accomplished is not the question that needs to be answered on this remand proceeding, because it is the infrastructure crossing facility that is the focus of this remand. And the question is whether the hub line needs a compressor station adjacent to its location in order to work. And the answer is it absolutely does not. Now, both the applicant and the department also cited the DPA regulation 301 CMR 25.01 in their briefs. And the language the 10 residence group has always felt supports the conclusion that this facility should not be located in this designated port area. The paragraph cited by the department on by the applicant on page 25 reads, because economic, environmental, and social factors now virtually preclude further development of such an intensive nature, what remains of the industrialized coast should be preserved not turn to compressor stations to the maximum extent practicable in order to meet the long-term cumulative space needs of the water-dependent industries that these areas are so well suited to accommodate. As a matter of state policy, it is not desirable to allow these scarce and non-renewable resources of the marine economy to be irretrievably committed to or otherwise significantly impaired by non-industrial or non-water dependent types of development, which enjoy a far greater range of locational options. There are thousands of compressor stations located around the country, and a vast majority are not located in DPAs or in Chapter 91 waterways licensed jurisdictions. There is a public park that the 10 residents group submitted affidavits during the underlying proceeding explaining the interference with their use and enjoyment of a public park in the Chapter 91 waterways jurisdiction. And much of the rejection of those affidavits was that they were speculative because the facility had not been built and the interference had not yet occurred. Now we have the interference. If this matter is remanded for further examination of this compressor station and its compliance, not just as an ancillary facility, but with all of the applicable Chapter 91 waterways rules and regulations, now the 10 residents group are in a position to call witnesses to testify how the last year and a half of compressor station operation, including emergency accidental releases of gas, have absolutely impacted their use and enjoyment of that public park. Finally, with regard to the environmental justice regulation, I am in agreement with both the applicant and the department that until this proceeding in this moment, none of the environmental justice laws were mandatory and required the department to apply them. Attorney Cramb was correct in stating that in the air quality plan approval proceeding, the minimum MEPA thresholds were not triggered. There was no environmental justice review that was conducted. The department decided it didn't have to. There may have been some additional outreach, but the substantive environmental justice review that the 10 residents group has been asking for across a number of proceedings for the last 6 years has not taken place. And to be fair to the department, it didn't have to until June of 2021. The new law has been in effect for almost a year, and it requires the department, including the DEP, in a Chapter 91 waterways proceeding to complete an environmental impact report if the project is located within 1 mile of an environmental justice community. And here we have at least 3. We have the Quincy Point community in Quincy, the Germantown community in Quincy, and Braintree, as a result of the latest census, also has an environmental justice community within 1 mile of the compressor station. This law is required to be implemented by the department, and as noted in the 10 residents group brief, the secretary may require that an assessment be performed at any stage of the review process. That's in paragraph 64 of the 10 residents group's brief. The reason why no appellate court was willing to require environmental justice review is because the record was closed, and the record from the underlying administrative agency proceeding was put before the appeals court and did not require any environmental justice consideration. Here we're in a different situation. This is a remand proceeding and an open matter for Chapter 91 waterways jurisdiction review. The new environmental justice law has been in effect for a year, and therefore it's the 10 residents group's position that on remand, it is an obligation for the department, 1, to determine whether there's an environmental justice community within 1 mile of this proposed facility. And 2, if the answer to that question is yes, the department must now complete an environmental impact statement in connection with this proposed project. In sum, Madam Presiding Officer, the 10 residents group respectfully submits that it is backwards to consider what the complicating factors are to relocate this compressor station elsewhere, because this compressor station is not the licensed infrastructure crossing facility. The focus of this remand should be the hub line. And there is no evidence that's been submitted either in the briefing that was filed recently or in the testimony that was taken years ago that establishes the hub line requires the compressor station in order to function. It's quite the opposite. The hub line's been working perfectly fine for 20 years. And that's my 15-minute timer. Thank you.
Thank you, Mr. Hayden. I'm going to ask you a question, and I'm going to ask the same question of Mr. Cramb and Mr. Fallon, and it relates to environmental justice. Is it your position that notwithstanding the language of section 102B of chapter 8, that the department, if this matter goes back to the waterways program for further review, that the department has and should exercise its discretion to apply sections 58 and 59.
It's my position and the 10 residents group position, Madam Presiding Officer, that the law now requires it. I think the only discretion that is afforded to the department is if review was not conducted earlier, whether to instigate review at any stage of the review process. And the reason I make that concession is the language in the statute that's cited in paragraph 64 of the 10 residents brief does state the secretary may require that an assessment be performed at any stage of the review process. So I agree that part of it is discretionary. What we dispute there being any discretion for is if there is an open project and it's within the Executive Office of Energy and Environmental Affairs. So that would include the DEP and would include a Chapter 91 waterways proceeding. If the record is open, then as of June 26, 2021, it's the law in Massachusetts that an environmental impact statement be completed by the reviewing agency.
But doesn't the language of 102B make that law prospective to new applications?
Sure, that would be the most inarguable point. But given the emphasis that has been placed on the importance of protecting environmental justice communities, it is the 10 residents group position, and understanding that this is a novel question, we're dealing with a brand new law. But it's our position that as long as the administrative proceeding has not closed, so for example, if the administrative record closed as of June 25th, 2021, I agree that the 10 residents group lose our argument. To the extent that any DEP related review, not on appeal, but DEP related review, including on remand, exists after June 26, 2021, it's our position that the environmental justice review covered in Chapter 8, Acts 2021 is required.
Thank you. Mr. Cramb, 5 minutes for response, please.
On that last point first, the residents have just misread the statute. It does not say if there is an open project or if there is a court remand that the statute applies. What it expressly says is that it applies the enhanced environmental justice requirements, quote, apply to new projects, and we contend that trigger the MEPA process, quote, filed on or after the effective date of the regulations promulgated under section 102A. And there's nothing about this project that is new. It would not make sense to go through a MEPA review at this stage of the case because, in fact, all of the other permits have issued and have been through an appeal process and have become final, including wetlands, air, and CZM. The environmental justice issues are far outside of the scope of what the court directed the department to do and what the commissioner directed you as the presiding officer to do. And this notion that this statute, which says that it only applies to new projects, should apply whenever there is an open project or when the record is not closed, just writes in words and concepts that are not there. Just as with respect to this point, most everything that you heard, with all due respect to counsel from the residents, is not relevant to this appeal. The question before you is not whether the hub line needs the compressor station to function. That's an argument that the residents made below and was rejected, and it is not within the scope of the court's remand order. It is also wrong as a matter of law because there are two questions in determining whether or not a facility is ancillary to an infrastructure crossing facility. They are whether or not it is operationally related and whether or not it requires an adjacent location. And what the residents would like to do here in a way that is completely inconsistent with what the court has directed is swap out the concept of operationally related for requires to function. It's outside of the scope and it's wrong as a matter of law. Likewise, the residents complain that somehow review was, appropriate review was prevented because the compressor station wasn't part of the hub line and its original license application. That again falls outside of the scope of review. And they actually concede in their brief that it's not the law. What they say in their brief is that they propose a rule where ancillary facilities should be evaluated independently, recognizing that that is not what is required and that an applicant, as is here, is free after a infrastructure crossing facility is licensed when it determines that there is an operationally related facility that requires an adjacent location, it may seek a license, just as Algonquin did in this case. With respect to one of the things that was in bounds that we heard from the residents, that relates to their interpretation of the regulatory examples. And on this point, we have a significant difference of opinion. But what I encourage you to do, Ms. Presiding Officer, is look carefully at the arguments that the residents have made in their brief with respect to each of these examples. What you will see is just repeated text again and again and again with respect to each of the examples that states a conclusion and includes no actual analysis. When you actually apply common sense and you think about the examples in the regulations, and the one that I think everyone seems to have kind of landed on as being the most practical is certainly the toll booth, it demonstrates the point. It's not that it cannot be technically located elsewhere. The question is, does it make sense to locate it next to the infrastructure crossing facility? Is it suitable and appropriate to do so? Is it thus demanded because it is suitable and appropriate? Not whether you can come up with some very complicated, very impactful, very expensive, very inefficient way to put it somewhere else. I think those are the points I wanted to address.
Okay, I'm going to ask you the same question, and I understand what the scope of this remand is. But my question to Mr. Hayden that I will ask to you is, if I find that the compressor station is not ancillary and remand it to the waterways program, does DEP have the discretion to require an EIR or conduct an environmental justice review, notwithstanding the language of section 102B of chapter 8 of the Acts of 2021? Could they do it if they wanted to?
Well, you are, in fairness, asking a question that does fall outside of the scope of review, and it's not one that I've set out to answer specifically, but I think the statute answers the question, and that is that it speaks very specifically to what it applies to, and it doesn't apply here. It does give the secretary some rights under the statute, but I don't think that's what you're asking. So I think the answer is no, that this is outside of the department's discretion.
Thank you. Mr. Fallon.
Thank you, Officer Rothschild. I would just like to address the statutory question on the new roadmap environmental justice statute. In the department's discretion on requiring an environmental justice review, should this matter be remanded to the program. And again, this was not something I prepared or briefed, so I am just giving an opinion as counsel under the plain reading of the statute. I don't think this statute will give us authority to invoke the statutory requirements of the roadmap to this application, even if it went back to the Chapter 91 program. However, our guidance on environmental justice, even though it does state that Chapter 91 license are not key agency actions, so they typically would not be required to undergo an environmental justice review, we would have the discretion to invoke that ourselves under our guidance.
Thank you. Okay, any further points, Mr. Fallon?
No, thank you. No.
Okay, Mr. Hayden, the last word to you.
Thank you, Madam Presiding Officer. I just have one more passage to read from Chairman Glick's order on January 20th, 2022. Chairman Glick from FERC stated, although it is cold comfort for the residents near the compressor station, I hope that this proceeding will serve as a turning point for the commission as we work to better consider, address, and act on issues of environmental justice. Partly in response to the lessons learned from the Weymouth proceeding, the commission has taken steps to ensure that individuals and communities have a full and fair opportunity to participate meaningfully in commission proceedings. In the last year, the commission established and filled a new senior role tasked with integrating environmental justice and equity into the commission's decision-making process, formally sought input on how we can consider environmental justice in various aspects of jurisdiction, and last but by no means least, created an Office of Public Participation to facilitate public engagement in commission proceedings. My great hope is that these changes will ensure that history does not repeat itself. We've come a long way in this proceeding in terms of rights that are being afforded to environmental justice communities. It was not soon enough in the prior proceedings. The 10 residents group submits that it is soon enough now. Section 102B that Madam Presiding Officer referenced does state the requirements imposed by Section 57 and 58 shall apply to new projects. That is not, to me, an exclusive statement. I've stated the discretionary feature in Section 57, 58, and 59 that the department may, in its discretion, apply. So to the extent that your question to the applicant, and I misunderstood your question to me earlier, included whether the department may, in its discretion, on remand, consider the new environmental justice law. The answer is absolutely yes. There's nothing in Section 102B that would preclude the department from examining the environmental justice impact of this facility. And with that, looking at the definition of ancillary facility that was remanded by the Norfolk Superior Court, stating that there was nothing unreasonable about limiting ancillary facilities to those for which a location adjacent to an infrastructure crossing facility is necessary. And again, the central question, whether the infrastructure crossing facility, the hub line, requires, demands, or makes the compressor station necessary because it is suitable and appropriate. The 10 residents group strenuously argues that that has not been established by the record evidence. Everything has been presented in the context of what the Atlantic Bridge project needs in order to get gas from Lambertville, Maine to Canada. And there is nothing that requires an adjacent location for the Atlantic Bridge project to site this compressor station facility on the north parcel. So respectfully, the 10 residents group asks that the presiding officer conclude that the compressor station does not meet the definition of ancillary facility under the regulations, and therefore all of the arguments that have been presented by the applicant and the department as to why this compressor station facility is suitable for this location should be re-examined on a remand proceeding by the department to include the question of its operation on its own, but also whether it serves a proper public purpose and whether this facility in and of itself is water dependent or non-water dependent. Those questions were not answered in the underlying proceeding because the compressor station was assigned the water dependent status of the hub line, and the 10 residents group respectfully requests that all of those questions be remanded for the department for further examination.
Thank you. That concludes the hearing. As you know, the remand order requires that I issue a recommended final decision on remand by a date sometime in August, and that is what I intend to do. So, and again, anyone who is watching on YouTube who wants the benefit of the full hearing should contact, if you are represented by counsel in this proceeding, please contact OADR through your counsel. If you are a member of the public, please contact OADR directly, and we will make sure that a copy of the Zoom video is provided to you. Thank you all.
Thank you.
Thank you.
Thank you.
Madam Presiding Officer, you'd like me to stay on?
Yes, please.